considered and both the courts have held that so far as.
Considered and held to be not proved.
Please.
Don't say considered. Moment you say not considered, I'll have to admit the revision.
No. And that apart, see, it is not rebutted. Your lordship has been telling.
Yes, Barkoli, heard. Shri Balaji Raghunathan and Girish Hegde, accused who suffered an order of conviction in CC number 338 of 2014 for the offence punishable under section 138 of the Negotiable Instrument Act and sum of rupees and imposed a fine of rupees 5,44,000 and 5,000 towards the state as defraying expenses confirmed in criminal appeal 312 of 2018 is the revision petitioner. First, next para. Facts in brief, which are at most necessary for disposal of the revision petition, are as under. Next para. Upon the complaint lodged by the complainant under section 200 CRPC, alleging the commission of the offence under section 138 of the Negotiable Instrument Act, contending that accused had approached the complainant for financial assistance in a sum of rupees 6,80,000 to perform the daughter's marriage of the accused and to discharge the debts during the year 2011, and he had agreed to pay interest at the rate of 18% per annum. First, when there was a failure to make the payment, there was a panchayat and parties were also required to visit the police station. And as per the panchayat, accused said to have tendered a check in a sum of rupees 4 lakhs to the complainant towards the final settlement.
No, humble submission, my lord. To Sumati, my lord, not to the complainant.
To the Sumati, and the said check was misused by the complainant by filling sum of rupees 4 lakhs. Full stop. That check on presentation came to be. No, I am only telling the case of the complaint. Why are you interfering? Which was settled in a sum of rupees 4 lakhs, and then by 4 lakhs as full and final settlement, and the said check on presentation came to be dishonored with an endorsement, funds insufficient. First, legal notice issued to the accused was not complied, inasmuch as accused did not claim the registered cover. First, cognizance of the offence was taken, accused presence was secured, plea was recorded. First, accused pleaded not guilty, trial was held. In order to prove the case of the complainant, complainant got examined as PW1, and 9 documents were produced before the court, which were exhibited and marked as exhibit P1 to P9 in support of the case of the complainant. First, as against the evidence placed on record by the complainant, accused got examined himself as DW1, and he placed on record a letter as exhibit D1, which was signed by the complainant, and marriage invitation cards as D2 to D4. First, accused statement was also recorded, wherein accused denied all the incriminatory circumstances, and thereafter argument was heard. And after considering the material evidence on record, learned trial magistrate convicted the accused for the offence punishable under section 138 of the Negotiable Instrument Act and imposed the fine of rupees 5,44,000, and the same was paid to be ordered to be paid as compensation, and default sentence of simple imprisonment of 6 months. Sum of rupees 5,000 was also ordered to pay as defraying expenses, as fine amount towards the defraying expenses of the state. Being not satisfied with the said judgment, accused preferred an appeal before the district court in criminal appeal number 312 of 2018. Next para. Learned judge in the first appellate court, securing the records from the trial court, after hearing the parties in detail, dismissed the appeal filed by the accused by judgment dated 4th January 2021 and confirmed the order of sentence. First, thereafter, accused is before this court in this revision. Next para. Reiterating the grounds set in the revision petition, Shri Balaji Raghunathan vehemently contended that the case of the complainant is a distorted version, And actually, the accused has handed over a blank check in favor of Sumati in the police station in settling the dues of Sumati, which was only rupees 1 lakh. And Sumati in turn has handed over the said blank check into the hands of the complainant, and complainant has misused the check by inserting rupees 4 lakhs, and therefore there was no legally recoverable debt, and complainant is a total stranger to the accused. First, next para. He further contended that though these evidence were placed on record, especially the exhibit D1, the letter executed by the complainant, signed by her and the exhibit D1A, learned trial judge failed to take note of the same, and ignoring the material evidence on record, wrongly convicted the accused, and wrongly convicted the accused, resulting in miscarriage of justice, which was totally ignored by the learned judge in the first appellate court, and sought for allowing the revision petition. First, next para. Per contra, learned counsel for the respondent complainant supports both the judgments. Next para. Having heard the parties in detail, this court perused the material on record meticulously. On such perusal of the material on record, it is crystal clear that the defense of the accused is that of the misuse of the check at exhibit P1. First, according to him, in respect of the dues that he was required to pay to Sumati, check in question was handed over to the Sumati in the police station. First, the said check was a blank check, and due payable by the accused to Sumati was only rupees 1 lakh. First, said check has been handed over to the complainant by Sumati, and thereafter the same is misused by inserting rupees 4 lakhs into the said check. First, next para. In other words, issuance of the check and signature found therein is not in dispute. First, according to the complainant, actually sum of rupees 6,80,000 was lent by her to the accused to meet the expense of the marriage expenses of his daughter, and so also the other family expenses. First, when there was no repayment, there was a panchayat, and parties were required to go to the police station, wherein she has given the concession of rupees 2,80,000, and the check was actually handed over by accused to her in the police station, and therefore there is no misuse. First, next para. In the case on hand, to prove the theory of misuse of the check, except the oral testimony of DW1, no other evidence is placed on record. Accused did not choose to summon Sumati to establish his case that actually check was handed over by him to the Sumati. First, under such circumstances, when the theory of the misuse fails, the learned trial judge, based on the material evidence placed on record by the complainant, rightly raised the presumption as is contemplated under section 139 of the Negotiable Instrument Act in favor of the complainant, and rightly convicted the accused.
Submission.
First, next para. The said aspect of the matter has been appreciated by the learned judge in the properly reappreciated by the learned judge in the first appellate court. As such, this court, that too in the revisional jurisdiction, cannot revisit into the factual aspects of the matter, especially when the evidence placed on record by the accused is not sufficient enough to rebut the presumption available to the complainant under section 139 of the Negotiable Instrument Act. First, next para. Accordingly, conviction needs no order of conviction needs no interference. First, next para. Having said this, it is seen that sum of rupees 5 lakhs was ordered to be paid as the expenses of the state. First, since list is privy to the parties and no state machinery is involved, imposition of the fine amount of rupees 5,000 to the state is totally unwarranted. Accordingly, following order, criminal revision petition is allowed in part while maintaining the conviction and conviction of the accused for the offence under section 138 of the Negotiable Instrument Act. Fine amount ordered by the trial magistrate in a sum of rupees 5,44,000 to be paid as compensation to the complainant stands unaltered, and ordering sum of rupees 5,000 as the expenses to the state is hereby set aside. Default sentence are as ordered by the learned trial magistrate in not paying the fine amount of rupees 5,44,000 stands unaltered. First, however, the time is granted to the accused to pay the balance fine amount till 30th of June 2024.
In submission, my lord, the criminal revision petition what I have filed was also not considered.
Sir, that's a matter to be urged in the appeal, not in the revision. Kavita? Kavita? Yen conviction, no? 138. Pass over. Prakasha? Prakasha, pass over. Ravi Kumar? Yen conviction, Ravi?
304 years.
ಎಷ್ಟು ಶಿಕ್ಷೆ ಕೊಟ್ಟಿದ್ದಾರೆ?
2 years for 304 ಗೆ 1000 rupees for.
ಎಷ್ಟು ಜನ ಅದರಲ್ಲಿ ಸತ್ತಿರ್ತಕ್ಕಂಥದ್ದು? ಒಬ್ರೇನಾ?
Operation.
ಹ್ಮ್.
In fact, before.
1 year reduce ಮಾಡಿ ಕ್ಲೋಸ್ ಮಾಡೋಣ ಅಷ್ಟೇ.
We have paid, I'm just bringing to the notice of this court.
No, payment cannot be,
Just ಹೇಳಿದ್ದು. We have spent about 2,80,000 for treatment and we have paid 2 lakhs.
that is the reason I am telling you, I will reduce it to 1 year.
Yes, that evidence says that my lord, he was drunk and he was passing.
PM report ಅಲ್ಲಿ ಇಲ್ಲ.
Here this.
PM report ಅಲ್ಲಿ ಇಲ್ಲ. ನಿಮ್ಮ ಅಕ್ಯೂಸ್ಡ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ನಾನು ಕರೆಕ್ಟ್ ಆಗಿ ಓಡಿಸ್ತಿದ್ದೆ, ಇವನು ಕುಡ್ಕೊಂಡು ಅಡ್ಡಾದಿಡ್ಡಿ ರಸ್ತೆಗೆ ಬಂದ ಅಂತ ಇಲ್ಲ. ತಾವು ನೋಡಿ.
Correct. I did not.
You also go to the extent of denying the very accident.
I did not conduct the act.
What to do? ನೋಡಿ, ಎಲ್ಲ ವಕೀಲರಿಗೆ ನನ್ನ ರಿಕ್ವೆಸ್ಟ್ ಇಷ್ಟೇನೆ. There is one judgment by the Supreme Court in Ravi Kapoor versus State ಅಂತ. ಇಲ್ಲಿ ಕೊಟ್ಟಿದ್ದೀನಿ, ನಿಮಗೂ ಕಾಪಿ ಕೊಡ್ತೀನಿ ನೋಡಿ. 39 ಪ್ಯಾರ ತೆಕ್ಕೊಡಮ್ಮ ಬೇಗ.
ನನ್ನ ಹತ್ರ ಒಂದು ಕಾಪಿ ಇದೆ ಸರ್, ಒಂದು ಬೇರೆ.
ಹಿಂದೆನೆ ಹೇಳಿದ್ದೆ ನಿಮ್ಗೆ ರವಿ, ಹಿಂದೆ 2021 ನಲ್ಲಿ ರಿವಿಷನ್ ಕೂತಾಗ್ಲೂ ಈ ಜಜ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದೆ ನಿಮ್ಗೆ, ಗೊತ್ತಾಯ್ತಲ್ಲ? ದಯವಿಟ್ಟು ನೋಡಿ ಇದನ್ನ. ಆ ಪ್ಯಾರ ನಂಬರ್ 39 ಓದಿ ಇದ್ರಲ್ಲಿ ಪ್ಲೀಸ್, ಎಲ್ರಿಗೂ ಅರ್ಥ ಆಗುತ್ತೆ ಅಂತ. ಏನ್ ಮಾಡ್ಬೇಕು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಅಂತ.
I'll read, madam.
Yes,
It is
please.
true that prosecution is required to prove its case beyond reasonable doubt.